Hey Realtors, it's Austin Small from the SCR legal team with an LLR update. You may have noticed that the Real Estate Commission has sent out a number of e-blasts and put a number of memos on their website in the last few months, and so we wanted to record this video to go through what you need to know about these memos and e-blasts. If you're going to yourself, that seems weird, I haven't gotten any e-blasts, what that means is the Real Estate Commission does not have your up-to-date contact information. That is actually a license law violation. So I would recommend, after watching this video, that you go to the LLR portal where you have your license and update all that contact information. Do not call the Real Estate Commission and say, hey, I have not been receiving the e-blast, because that is calling the Real Estate Commission and admitting that you are not in compliance with license law. Just go to the portal and get your information updated so you can be up to date with all the e-blasts and all the other information the Real Estate Commission puts out. So, what has been some of these e-blasts and these memos that have been disseminated in the last few months? The first is regards to non-residents in CE. So under the license law that was passed in May of last year, the exemption that was in statute allowing for non-residents who have licenses in other states to use their CE from those states for renewal in South Carolina was removed. Meaning that if you have a license in another jurisdiction, you will need to still get the 10 hours of required CE credit in South Carolina in order to renew your South Carolina license, unless you meet one of the other statutory exemptions for years of service or age. The next memo I want to discuss is one that was sent out to brokers in charge. This regards office inspections. The Real Estate Commission under statute has the right to conduct office inspections, and that is something that they are planning to doing more earnestly in 2025. So that alert was simply to make you aware that they will be doing so. If you receive a call or correspondence from the Real Estate Commission about scheduling an office inspection, that is not a scam. You need to respond promptly. That is a requirement of license law. The Real Estate Commission is working on a checklist. There is a task force that was created last year to create an updated checklist of what to look for when there is an office inspection. The SCR is going to be pushing the Real Estate Commission to get that released as soon as possible, and as soon as we have it, we will make sure that you do as well. But now that we've discussed the e-blast, I want to discuss the 4 memos that are currently available on the Real Estate Commission's website for you to read, but wanted to kind of summarize what each of these are. These are statements that have been put out by the Real Estate Commission after discussion of these matters that they have received a lot of inquiries about in the past few months. The first is about showing agents. We received questions about that on the hotline a bunch as well. Hey, can I use a showing agent? I'm not going to be in town. Can I have somebody else show property for me? The long and short answer of it is if that person is not a member of your brokerage, then it is no. Why is that? You cannot have an individual who is unlicensed show property because that is barred by statute. Secondly, you as a licensee cannot pay someone else to do real estate services, as all real estate payment must come from the brokerage in charge. And third, you cannot do this because your client signed an agency agreement with your brokerage firm. This individual, this showing agent who is outside of your brokerage, is not covered by that agency agreement. The consumer is likely not aware of this. They're not covered by it. There is no confidentiality, so it is a breach of that agency agreement. So if you need someone to cover your property for you or work with your client because you're out of town, have someone within your brokerage do it, because anyone within your brokerage firm can assist that, because the client relationship is with the brokerage firm, not you individually. Next, there's a memo they put out about coming soon, whether or not you can advertise a property as coming soon. So here's the distinctions they made in statute. 1, in order to advertise any property, you must have a written active listing agreement to do so. So kind of break that down a little bit. What does that mean? The agreement must be in writing. You have to have a written listing agreement that fully details all the items that are required under statute to be in the listing agreement, and that agreement must be active. So if you've signed a listing agreement today, but it doesn't take effect for 2 weeks, you don't actually have any relationship with that seller for 2 weeks, so you cannot talk about their property. You can advertise it as coming soon at that point under statute, but I would remind you to be in compliance with all MLS and clear cooperation rules when doing so. But you cannot advertise anybody's property, period, without first having a written active listing agreement to do so. Next, we're going to discuss the memo that they put out about advertising. This was to highlight some of the changes in the recent license law regarding advertising. In particular, 2 questions were raised by the Real Estate Commission in this memo. The first is, Can I advertise the listing of another brokerage? The answer is yes, so long as two criteria are met. First, you must have written authorization by the listing brokers to do so. And second, you must give them proper attribution in the advertisement in a clear and conspicuous way, meaning that it must be clear to anyone who looks at that advertisement that they are aware that the listing brokerage is not you, but is another brokerage, and you have written authorization to do so. Of course, the listing brokerage will make sure that they have authorization by the seller in order to grant that permission. The brokerage can, vet whatever information you're putting out there to make sure it's correct. If the advertisement is changed and incorrect information is put out, the individual who changed that information will be likely the one who's held responsible. And the second thing is a change in license law about generally advertising your services but not advertising a particular property. So under the previous law, if you just wanted to have a billboard on the side of the road that just says, contact Austin for all your real estate needs, there was no requirement that your real estate brokerage firm be on that advertisement. That is no longer the case. Whether you are advertising property owned in whole or part by somebody else, or you're advertising your general real estate services, the full name of your brokerage firm must be on all advertising in a clear and conspicuous way. And then lastly is the memo I want to address that they put out about wholesaling. This is one of the major changes in the license law that was passed last year. And so the commission wanted to really dive in and tell you what is and what is not wholesaling. So wholesaling is defined in statute as advertising and marketing the whole property when all you have is a contractual interest. Statute says that cannot be done without a real estate brokerage license because you cannot market property owned by somebody else without a real estate license. And it also says in statute that wholesaling or assisting anybody with wholesaling is not allowed under statute. So what you cannot do or assist anybody in doing is advertising property for sale without actually being the deed holder. So if you have a contractual interest in the property, that's all you actually have is a contractual interest. You do not have the right to sell the home. You do not have a right to advertise to the public that you own the home. So you can advertise your contractual interest in the property, but statute says that if you were to do that in any advertisement, you cannot purport, suggest, or imply that you actually own the underlying property. I will let you know that wholesaling is something the commission is particularly laser focused on. So any violations of that, you're likely to move to the front of the line. If you have questions on this memo or any other memos or any of the e-blasts that you received from the Real Estate Commission, don't hesitate to reach out to myself or any other member of the SCR legal team. The best way to reach me is my email address, austin@screaltors.org. Thank you for your time and attention today.